Good morning and welcome to the PSPRS Continuing Local Board Training Webinar Series. We would like to welcome both our in-house participants and our participants viewing this presentation online. We hope that these webinars provide you with useful information that assist in fulfilling your roles as appointed or elected member, local board secretary, or local board staff. We here at the system look to our local boards to ensure that they administer all the provisions of the PSPRS and CORP plans accordingly. Today's webinar is PSPRS and CORP Return to Work Rules. Before we begin, a couple notes about this presentation for our online participants. Should you have a question, please feel free to type your question in the box provided on the upper right-hand side of your screen. We'll be providing some time at the end of the presentation to answer questions by both our in-house and online participants. These webinars are just one of several training tools that we provide to our local boards. Should your board wish to host an on-site training event, please contact myself or Don Minear by calling 602-255-5575 or by emailing myself at rortega@psprs.com or don@psprs.com. Today's presentation is a topic that our office has received many questions on in the last year. In an effort to recruit highly experienced law enforcement, fire, and corrections personnel, many employers look to retired members of our plan. However, if that employer is a participating employer in our system, it is important that they understand under what conditions they can re-employ PSPRS and CORP retirees without jeopardizing their pensions or the system's tax qualified status. Additionally, it's important for the local boards to understand these rules as well in order to better educate their membership and their partner eligible employer groups. We hope today's presentation will shed a little more light on the subject so that our participating employers and local boards understand their responsibilities in this process. So let's go ahead and begin. Today's objectives, we are going to basically be going over and have a brief discussion on why the work rules are in place. Obviously, as a system, we have specific requirements that we have to uphold to, and these work rules are just one of those requirements. So we'll talk a little bit about the return to work rules, as well as what the system does with respect to that, how we get involved, how we associate and educate our employer groups and our local boards. We'll also review the statutory provisions governing these retiree return to work rules. You know, under what specific conditions can these retirees return to work and without jeopardizing their pension, as well as what the employer and local board are responsible for. As you can see, that would be our next topic, which would be to ensure that the local boards and employers are in compliance. We'll talk about what steps they need to take in order to make sure that they're within the provisions of the statutes. From there, we'll have a brief discussion on the alternate contribution rate. This is something that is relatively new to the system. And with respect to hiring retirees, there may be situations under which the employer would be responsible for this alternate contribution rate. And then finally, we'll talk a little bit about some frequently asked questions that we here at the system have received by both membership as well as local boards. And then, of course, we'll be going to the question and answer session from our participants in today's webinar. So let's go ahead and start with why we established the return to work rules. Well, why are they in place? As you may or may not know, our system is a system that is considered a tax-qualified system under IRS rules. Specifically, it would be under IRS Code 401A, being a defined benefit plan, and specifically a defined governmental plan under 414D. What those rules are in place for is, or being a tax-qualified system, there are certain provisions that the IRS require in order for us to maintain this qualified status. One of them being that we have to administer the plan in accordance to our plan description. And for us, our plan description is basically the statutes, Title 38 to be specific. So when we are giving benefits to members, or when members qualify for benefits or even qualify for membership, we look to the state statutes and the provisions associated to make those determinations, or the local boards making those determinations and eligibility requirements. So that's kind of like our summary plan description. And that's one of the requirements under IRS rules to meet those type of qualifiers under the code. And then specifically why return to work rules were put into place is under the IRS rules, or under IRS code, they require that a bona fide separation of service has to occur in order for someone to meet the definition of retirement. One of the problems, or not so much problems, but one of the issues with that is the IRS doesn't clearly define what retirement is. All that they basically state, and there are some case laws associated, that just basically say that there needs to be some sort of bona fide separation of service that occurs in order for retirement to truly commence. So with that said, our legislators, obviously who set state statutes, developed these return to work rules to hopefully provide guidance to our employer groups and as well show to IRS that we do provide some rules in place that show that a bona fide separation of service does occur. So what is the administrative office's role in this whole process? We here at PSPRS, how do we get involved and what is our responsibility when it comes to return to work rules? Because as you know, as local boards, you guys have all the vested responsibility and duty to determine eligibility for benefits, determine eligibility for membership, etc. But what is the role of the system when it comes to the return to work provisions? Well, one of the main things that we are responsible for, and it is in statutes, is that the administrative office does review all decisions, including return to work actions that are taken by both an employer and local board. So that is just like with any other type of decision that's made, including disabilities, membership, normal retirement. We here at the system review those decisions that are being made at the employer and local board level to ensure that they're in compliance with state statutes. Because again, our ultimate goal at the administrative office level is to ensure compliance of statutes so that no jeopardization of the tax qualified status under IRS rules is occurring, because that is our ultimate goal, is to ensure that the plan in its entirety is covered and protected. We also are responsible for, or we take the responsibility to assist and educate our employers and local boards on these return to work rules. Main reason why we're doing this webinar today. We want to make sure that our employers and local boards understand what those conditions are in which you can hire back a retiree from the plan. So we have our local board training department here in place to help our employer groups and local boards determine how a return to work should occur and under what conditions to ensure that the member doesn't lose their pension. And that's kind of that third bulleted point there. We just want to make sure that we're protecting our members. We understand that these return to works and reemployment of retirees are occurring, but we don't want to jeopardize that member's pension so that they can continue to receive that benefit out of the system. And again, ultimately, we don't want to violate the rules of our own plan, which then puts our tax qualified status in jeopardy at the IRS or federal level. So as you can see here on this slide here, we're going to go ahead and start off and talk a little bit about public safety first, and then we'll move into CORP. But under this slide here, this is basically the section of statutes that governs return to work, and that is under ARS 38849D. As you can see, there's a lot of information in there, so I can understand how, from an employer or local board perspective, it could be a little confusing on what are exactly those rules. When can I hire back a retiree? So you can absolutely take the time to read the statutes, which we always recommend that you do. But let's go ahead and move on to the next slide, and we'll basically take what that information is and what does it mean under public safety. Well, under 38849, what the return to work rule is it's basically guided towards a return to work of a retiree to the employer from which they retired from. That is ultimately the biggest issue, is when I retire from, say for instance, the city of Phoenix, and I'm potentially looking at opportunities to come back into employment with the city of Phoenix, under what conditions can a PSPRS retiree do so, and under what conditions can an employer make the hiring decision? Of course, they make a hiring decision however they want, but under what conditions, without jeopardizing the member's pension, could they make these hiring decisions? Well, as you can see here, in order for that to occur, that PSPRS retiree cannot be reemployed in any paid position We're not just looking at public safety covered positions, but we're looking at any particular paid position that you as an employer have an opportunity for this member. So they cannot return back in any paid position with that employer from which they retired from until they have been retired for at least 60 days. And as you can see on the slide here, you need to remember that effective retirement is always the first of the month following the individual's termination. And that's across the board in both plans. Retirement is always effective the first of the month following their termination. So in order for the individual retiree to return back to the employer from which they retired from under this particular condition, they need to ensure that their return to work and reemployment commences after 60 days in any paid capacity. If it happens prior to that, again, the employer is more than welcome to make that hiring decision, and the member is more than welcome to take that position prior to the 60 days, but if they were to do so, their pension would have to cease. The second condition in which return to work rules would come into play is if that retiree is returning back to the employer from which they retired, and additionally they're returning back to the position from which they retired from, then that is another potential violation of return to work rules, and as such that member's pension would have to be suspended. So as you can see here in the slide, I have an example here. You have a retired fire captain returning back to the employer from which they retired from in the same capacity as a fire captain. In the statutes under 38.849, they do have the discussion of what similar duties mean. And that's basically you're coming back and doing exactly the same position that you were doing before you retired, exercising the exact same authority as the position you had prior to retirement. So if you're doing exactly the same thing, if that member is going to be doing exactly the same position that they did previously, then that is a violation of the return to work rules, and as such, the member's pension would have to cease. Again, the member and the employer are more than welcome to make those hiring decisions, but the member needs to understand that under that condition, their pension would cease. And then finally, the third condition is if the retiree was on a disability and receiving disability pension payments, and they return back to work under this particular situation, if they return back to work in a public safety position, then they no longer would receive pension benefits. They actually would become an active contributing member again. So if they're receiving a disability benefit and you as an employer are rehiring a PSPRS retiree into a PSPRS position, then this individual's pension would cease and they would then turn into an active contributing member again. And then under that particular situation, once they're normal retirement eligible, we would go through the normal processes of processing a normal retirement, looking at service and credited service. And credited service for this particular individual under this circumstance would be all of the time that they contributed into the plan as in normal statutes, but the time in which they were receiving pension payments, that would be considered an uncompensated leave of absence, and as such would be leave without pay and reduce the individual's credited service. So that was public safety. Let's go ahead and move forward now and talk a little bit about CORP and the CORP return to work rules here. Under CORP, it's a little bit more streamlined in terms of under what conditions a retiree can return back to a CORP employer. The section of statutes that governs return to work for CORP is under 38.884K. And again, I have a copy, as you can see here, this is the statutes taken directly from that section. I'm not going to read it word for word. You're more than welcome again to review that statute at your leisure. But what does that section of statute mean? Well, under 38.884, in order for a CORP retiree to return back to a CORP employer and still continue to receive pension benefits, that individual cannot return back into a CORP designated position, any CORP designated position, until they have been retired for at least 12 months. Again, remember, effective retirement is the first of the month following termination. Under CORP, it's a little bit more different than, or I should say, it's a little different than it is under public safety in that we're not just looking specifically at returning to work from the employer from which you retired. Under CORP, the way the definitions are set up, they are looking at CORP designated positions with all CORP employers. So the individual is not just bound by the employer from which they retired from, they are actually bound by any CORP employer in our plan. For instance, you have a Department of Corrections retiree looking and seeking opportunities with Maricopa County Detention, who is a CORP participating employer, and they have an opportunity as a detention officer. That individual, in order for them to continue to receive their pension, cannot take that type of position because that is considered a CORP designated position until they have been retired for a year. Again, the member and the employer is welcome to reemploy that individual prior to that, but if they were to do so, it's in violation of the return to work rules, and as such, that individual's pension must cease. So under CORP, it's a little bit more clear-cut in that it covers all CORP designated positions with all CORP employers, not just specifically to the one employer from which the member retired. So now that we talked about the statutes and what the statutes mean, let's talk a little bit more about what the responsibility is for you as an employer or as a local board, and what steps you need to take and some best practices that maybe you need to put into place to ensure that you're making the proper decisions and employment actions that wouldn't violate return to work rules. So let's start off with our employers. What are your responsibilities under public safety? Let's talk a little bit about that first. Well, one of the first things any employer should probably put into place, whether it is through your onboarding process or new hire paperwork, whatever process works for you, is you as an employer should find some way or put into place some sort of mechanism to determine if any newly hired employees are retirees out of the system. That would be one of the first things you'd want to look at. Are they a retiree from public safety? Are they a retiree from CORP? And the only way to do that is to have some sort of procedure in place, whether it's some sort of self-identifying document or, reconciliation with the system, contacting the system and making those type of inquiries. Whatever works for you as an employer, I would highly recommend putting that type of process into place, putting some procedure to identify those individuals that you are hiring back, or any new hire, just to ensure that they're not retirees. The next step as an employer you should be aware of or put into place is, again, some sort of procedure in notifying your proper local board on any hiring decision that was made to reemploy a retiree from the system. If you are a PSPRS employer and you are rehiring a PSPRS retiree, you should be contacting your particular PSPRS board, especially if you have identified that PSPRS retiree is a retiree from your particular group. So if you are the City of Phoenix who has a retiree from the City of Phoenix and they were a PSPRS retiree, you should be contacting your particular board. Do understand as well as an employer that you may have multiple boards. Again, going back to the example of City of Phoenix, you have both a police board and a fire board. So you need to ensure that you're contacting the proper board on notification of a retiree that you have now rehired. So you've hired back a fire retiree, you should be contacting your fire board so that they can then begin their process with respect to return to work decisions. And then same thing would go for our CORP boards, making sure you put it into procedure some way to notify your particular CORP board. With CORP, it's a little bit different because if you are an employer who's hiring back a CORP retiree and they're not a retiree from your particular group, your local board really isn't going to be taking the action to make a determination on return to work. It would be the other board's responsibility. again, going back to the example of Department of Corrections retiree going back to Maricopa County, and Maricopa County hires them, it's not really Maricopa County's board's responsibility to make the return to work determination. It is ultimately the Department of Corrections' responsibility. But there should be some process in place in which Maricopa County gets in contact with the Department of Corrections, whether it's through notification to our office or contacting them directly. But again, there needs to be those procedures in place that the board gets notified to some capacity. I would like to note, though, for our public safety employers, there actually is some specific language in statutes that puts requirements on them, that they should be making specific notifications, and specifically to our office here at the administrative offices, on any reemployment decisions. And when that PSPRS employer is responsible for doing that, it is under the conditions in which you as an employer have hired back a retiree from your account. So again, going back to the example, I'm the City of Phoenix. I have hired back a public safety retiree from the City of Phoenix. Within 10 days, under statutes, you must notify our office of that decision or that employment action. If you are a City of Phoenix, or if you are the City of Phoenix and you're hiring back a retiree from the City of Mesa, that requirement isn't really necessary to be put in place, but I think it's still a good practice to still notify us of any reemployment of a retiree. But just note that it is specifically put into statutes that when it's a retiree from your account, you must contact our administrative offices. Then finally, the next and the last responsibility the employer should be looking at is, once you've identified any retirees that you're reemploying from our plans, then determining whether or not the alternate contribution is going to be required on behalf of that newly hired retiree. And we'll talk a little bit about the alternate contribution in just one moment, but I just wanted to bring that up here because, again, that is a responsibility of the employer to determine whether an alternate contribution does come into play. So now let's talk a little bit about the responsibilities from the local board perspective. Well, from a local board perspective, you should, as any local board best practice would be, is developing some procedures to ensure that the employers are notifying you on those reemployment decisions that are being made with respect to retirees. If you don't have any type of mechanism in place, I would highly recommend that you start working with your employer group on developing some sort of notification system so that you are put on notice when they have hired a retiree from the plan. And again, specifically when it comes to public safety, it is even more critical when it is a retiree from your account, because you must be making a reemployment decision to determine whether or not return to work provisions have come into play. When it comes to CORP, you may or may not be the board in which the member retired from, but you should still have a mechanism in place, because then you should be following up with either the other board and notifying them on that decision that's been made by your employer, or if you, again, are the employer from which the member retired, then making that determination on whether or not it meets the criteria under statute. And then obviously by finding that information out, you have the vested responsibility to determine whether or not there are any violations to those return to work rules, and as such would require action to suspend the retiree's pension. Under CORP, it's because of the uniqueness that it covers any employer and any CORP designated position. A lot of the times, and it hasn't happened frequently here, but the few times that it has happened here at the system, we actually have been notified prior to the board being notified who the member retired from. Meaning, Department of Corrections has a retiree, and now this retiree is employed by Gila County in a CORP designated position. We probably are going to be notified quicker than the Department of Corrections would be notified of that reemployment action, just because of the pure situation in which Gila County may be submitting contribution in error on behalf of that individual, or we receive a membership form in error on behalf of that individual, or Gila County just calls us and asks us directly. And so as such, we would then contact the Department of Corrections and let them know. But we also, because we have the vested responsibility to ensure compliance to statutes, if it is in violation of those return to work rules, and the same thing would go for public safety as well, if through information searches that we have gotten through employers or by members, we have determined that there is a violation of return to work rules, we may take the immediate steps to suspend that pension with further final determination by the local board. Because again, the local board is vested with that responsibility to determine eligibility, but because we know that the violation is in place, we may take the immediate steps to suspend that pension with the ratification of that action by the local board. So just be aware of that as well. So hopefully that's given you a little bit of guidance on a local board perspective and employer perspective on what type of responsibilities you should be doing to ensure these return to work rules are being addressed. So now let's talk a little bit about the alternate contribution rate. What is the alternate contribution rate? Well, like I mentioned earlier, this is a relatively new requirement to an employer with respect to hiring back retirees. And what the alternate contribution rate is, as you can see here from this slide, it is strictly an employer-only contribution requirement. So this is something that the employer is required to pay on behalf of a reemployed retiree, not an employee. So you should not be withholding contributions from this reemployed retiree. You as the employer, by making the decision that you made to hire back a retiree, are responsible for this alternate contribution rate. And we'll talk a little bit in just one second on under what conditions this alternate contribution rate comes into play. When it comes to submitting this contribution, it's no different than how you would normally submit contribution with normal payroll, meaning that you would want to follow the same protocols if you're utilizing our online employer system to submit contributions and submit detail of those contribution totals that are coming to the system. You just want to follow the same sort of procedure. What's going to happen is you're going to have two separate recordings or notifications. You're going to be submitting contributions and detail for your normal payroll, meaning your active contributing members like you normally do, but then you're also going to have to do some sort of notification, upload, submission of contribution separate for this alternate contribution rate. And there'll have to be detail associated to that contribution that's being submitted as well. So when does this rate apply? As you can see by the third bulleted point here, the rate is applied to any retiree who is reemployed into a position that is traditionally covered by the same plan from which that member is receiving pension benefits. Meaning you are a PSPRS retiree, or they are a PSPRS retiree, and you as an employer have hired them back, and the position in which they are filling is a PSPRS covered position. So police officer position, fire position, if you are hiring them back into a traditionally covered PSPRS position, this alternate contribution would come into play. Same thing goes for CORP. You are a CORP employer who has reemployed a CORP retiree into a CORP designated position. The alternate contribution comes into play. It doesn't come into play if you are a CORP employer hiring a PSPRS retiree into a CORP designated position and vice versa. It's only when you are dealing with retiree filling a position in the same plan in which the member was retired from. What amount is contributed against is based upon statute. And again, the fourth bullet point here shows that you're submitting contribution on compensation, and compensation as defined in statute, as well as contract fees. The section of statutes governing alternate contribution rates does address the contract fee that you may be applying to a member. Meaning, you may not have fully hired them as an employee into your employment, but you've contracted their services into a position that normally is filled by an actual employee. So under this circumstance, even if you are contracting their services, it's still covered under this alternate contribution rate, because had you not contracted their service, you probably would have filled it with an active contributing member, because that position is doing the same job and is a covered position under statute. So that if you're using them as a contractor, you still would be responsible for that alternate contribution rate. So how is that rate set? As you can see on this slide, the alternate contribution rate is set each fiscal year. The example that I have here on this slide is taken from our consolidated reports for public safety only, and this is the most recent consolidated report. So this would be for fiscal year ending June 30th, 2011. The rate is determined by combining the amortized unfunded liability for both pension benefits and health subsidy benefits. So as you can see on this little arrow here, that line that shows those percentages, that is where the alternate contribution rate is derived. It is important to note that the alternate contribution rate is taken from the aggregate total of all of our participating employers. So we look at the consolidated reports to determine alternate contribution rate. The alternate contribution rate is not specific to each individual employer. It is one rate for all PSPRS employers and one rate for all CORP employers based upon the consolidated reports. So as you can see on this slide, for 2010 fiscal year end, based upon that information, that's where we determined that 10.51 is the alternate contribution rate that you as an employer should be paying on behalf of individuals who meet this criteria, because this section of statute did go into effect as of July 20th of 2011. So if you have any members, retired members who are in covered positions of the plan from which they retired, we should be receiving alternate contribution rates already on their behalf. And this goes with those members as well as any future retirees that you may have in the same position. So now that we talked a little bit about all of our return to work rules, responsibilities, duties, and that ACR, let's go ahead and move forward and do a little bit of these frequently asked questions. A few of these questions that I'm going to be posing here are actually taken from a listing of frequently asked questions that we have developed within the last year, couple years actually, based upon questions that are submitted by members, by local boards, by employers to kind of better understand these return to work rules. So we've developed a series of frequently asked questions that actually can be accessed from our website, and we have them broken out by member-related questions versus employer or local board-related questions, and they're on each of the individual's main pages for the plans. So if you go to our main page, which is PSPRS.com, you'll notice that at the top of the web page we have the three different buttons for the three different plans, whether you're public safety, elected official, or CORP. You would just click on that particular plan and it would take you to the plan main page. On the left hand side, you'll notice on that plan main page the section that talks about FAQs, or the frequently asked questions, and that is where we would house the FAQs for return to work questions. So these next couple questions that I have on slides are derived from those listings. If there are questions as you begin to deal with these return to work rules in your situation, if there's questions that aren't addressed on those frequently asked questions, please feel free to give us a call, send us an email, and we may be adding those to future listings as we update information. So let's go ahead and talk a little bit about some of these questions. We're going to take it first from the perspective of questions by members, and then take it from a question from a local board or employer perspective. So our first member question is, I plan on retiring soon, and I would like to return to work with my same employer and still receive my pension. Under what conditions can I do this? Well, as I've mentioned earlier in our presentation, for our PSPRS retirees, because we're just concerned under statutes, a return to work with the same employer from which you retired from, or which they retired from, in order for that individual to continue to receive their pension, they cannot return to work in any paid capacity within 60 days of their retirement. So again, they need to sit out that 60 days before they return to you as the employer from which they retired from in any paid capacity. So we're not just looking at the PSPRS covered positions. We're looking at any paid positions that individual may qualify or be eligible for reemployment on. If they go after the 60 days, there would be no return to work issue, and as such they can continue to receive their pension. But if they do it prior to that, there could be a violation of the return to work rules, and as such their pension would be suspended. You also need to remember as a member that they cannot return back to the position from which they retired from. So as an employer, from an employer perspective, you need to make sure that when you are hiring back these members, that you're not hiring them into positions from which they retired. Because if they have, regardless of whether or not they have sat out their 60 days, their pension would still stop because they're returning to the position from which they retired. I'd like to note, though, that the returning to work as an unpaid volunteer does not require that 60-day waiting period. I know we've gotten several questions from employers with respect to coming back as a volunteer officer, unpaid sworn officer on a volunteer basis. Is that acceptable, and do they still have to sit out the 60 days? Our interpretation based from our legal counsel is that if it's an unpaid volunteer position now, we are not concerned with that. We're only concerned with actual paid employment. So just like to put that out there. From the CORP retiree perspective, as I mentioned before, here it's a little broader when it comes to returning back to work, because we are looking at any CORP employer in any CORP designated position. And in order for that member to continue to receive their pension, they cannot return back to a CORP designated position until they have sat out for 12 months. So, and this is with any CORP employer. So again, Department of Corrections to Maricopa County or Department of Juvenile Corrections, if that employment is in a CORP designated position with those employers, there could still be a return to work violation based upon when they return back, because they must sit out 12 months. If they're the Department of Corrections CORP retiree going to Maricopa County, even though they're a CORP employer, they may have a position that's not CORP covered. That's fine. We're not concerned with that. We're only concerned, or the system is only concerned with CORP covered positions. Our next member question is, can I retire with a normal retirement and return to work with a different PSPRS or CORP employer in a position covered by the plan that I retired from and still receive my pension? Well, for PSPRS retirees, yeah, that's acceptable. There are no provisions under the return to work rules that address a retiree from PSPRS going to another PSPRS employer in a PSPRS covered position. That is fine. There's no 60-day wait in that situation. It's there under PSPRS rules. We're just concerned with the employer from which the member retired. So you could stop one day or retire one day with the city of Phoenix as a retiree in PSPRS, be hired back with the city of Chandler in a PSPRS position the following week, and not be in violation of return to work rules, and could continue to receive your pension. However, it's important to note, going back to that alternate contribution rate, City of Chandler would then become responsible for an alternate contribution rate because you have hired back a PSPRS retiree into a traditionally covered PSPRS position, and then the City of Chandler would be responsible for paying the ACR. For CORP retirees, again, going back to the statutes, it's a little bit more broad in that you can go to another CORP employer into a CORP designated position, but you still have the return to work rules in place for you in those situations. And again, you need to make sure it happens 12 months after retirement. Once they've sufficiently met that requirement, they can return back to a CORP designated position with any CORP employer. But again, remember, from the employer perspective, that ACR would be coming into play, and you would need to be submitting the ACR on their behalf. So now let's take a local board question, or local board employer level type question. Does the system have specific requirements or documentation that the local board and employer must provide when handling a reemployment of a plan retiree? Well, for PSPRS, there's a couple things that you, as an employer and as a local board, should be looking at. When it comes to required documentation or required notifications under statute, the system does require that an employer notify our office in writing of any reemployed retiree that was a retiree from their account. Again, that's taken from statutes. The employer is required to notify our office in writing within 10 days of reemployment of a retiree from their plan. And that in writing can be whether we don't have it stipulated of whether it's writing, hard writing, mail, standard mail submission, or by email. We just need to be notified in writing of a reemployment decision that was made to hire back a PSPRS retiree from your particular account. It's important to note from an employer perspective, though, that if you are reemploying a retiree from another PSPRS employer, then the written requirement is not necessary. It's not required. However, going back to best practices, you might want to still continue to notify our office, because we still want to know, we would still like to know that PSPRS retirees are being rehired into PSPRS, potential PSPRS positions. And we want to ensure, again, our ultimate goal is to ensure that the member's pension isn't in jeopardy and that the tax qualified status of the plan is not in jeopardy. So even though by statute you're not required as an employer to notify us, you should still probably make it a best practice to notify us in writing. From a local board perspective on PSPRS return to work rules, I know we have given guidance previously that kind of dictated that we needed to provide, you as local boards needed to provide affidavits, signed affidavits by the employer, by the employee, that there was no pre-existing agreement. We needed to have copies of job descriptions of position held before, position held after, and minutes, detailing all of the employment decision process and how you came to the decision that you as a local board came to, whether or not a suspension of pension is required. Our office has, obviously, with all these questions that have been coming up, have been doing a lot more research with respect to the IRS guidance and rules associated with bona fide separation of service, or this quote-unquote definition of retirement. And these initial guidance that we have provided and requirements that we have put out to the local boards have kind of been based upon that initial research. But as we continue to further understand what the IRS is fully looking for when it comes to bona fide separation of service, please note that we may be adjusting or we may be making different requests with respect to what true information we are going to be requiring from local boards. What should be noted, though, is that we still need to have from the local boards enough information through minutes, through documentation and supporting documentation that you as a local board have created or received from an employer to ensure that the decision that you made on whether or not the member's pension has to be suspended because of return to work rules, that still is a requirement. We still need to have, at the administrative office level, sufficient information to say, yes, we agree with the decision that you as local board made, or no, there's some additional information that you need to seek to ensure that the statutes are being met. So while we may not necessarily always continue to require this pre-existing affidavit agreement or all these job descriptions, we are going to still need sufficient documentation that shows that you as a local board came to a decision that's within the provisions of statutes. So Should you continue to use our recommended requirements, I would highly recommend that you continue to do so until you receive any type of further guidance from the system here. When it comes to CORP, like I mentioned before, because of the broadness of the CORP, all CORP employers and all CORP covered designated positions are covered under this return to work rule for the first 12 months. We may have to follow up individually with those local boards to have them make their decision on return to work rules. But again, you need to ensure that if you as Department of Corrections are taking an action to review a reemployment decision made of a CORP retiree, you need to ensure that there's enough sufficient documentation and information put into minutes that shows that you came to the decision that was within the provisions of state statutes. So with that, we'll go ahead and transition to our question and answers that our online participants and our in-house participants may have. So again, if you'd like to type in your questions, we'll go ahead and wait 1 second while these questions come in and address those questions that our online and in-house participants have. Okay, it looks like we do have some questions that have come through, and we'll go ahead and get those going. We have our first question here. Just to clarify, for PSPRS, we would need to do the following. 1. We have to send PSPRS information on a reemployment of a former employer within 10 days of date of hire and the current position that the employee was hired to. 2. We send the information to our local board. And 3, a determination would be made by the local board, and we send PSPRS the information for a final determination. Is this correct? Also, during this time, would the pension of the member be automatically suspended without the local board review? Well, let's take each of these different sections of these questions. For PSPRS employers, yes, under statutes there is a 10-day requirement in writing to our office of a reemployment decision that was made by you as employer to hire a PSPRS retiree, especially when it's from your account. Within that, in statutes, there are requirements that we do need to know the position that they are hired into, because again, under PSPRS rules, we're not only looking at the 60-day in any paid capacity situation, we are also looking at whether or not that reemployment of a retiree was into the same position from which they retired from. So yes, you do need to notify us within 10 days. The second part was, do we send this information to our local board? Yes. Like I mentioned before, it's important that there's a partnership between employer and local board when it comes to reemployment decisions, especially when it deals with retirees from your account, because the local board is vested with the responsibility to determine if that member is still eligible to receive that pension. So you would need to still send this information to the local board. The third section, a determination would be made by the local board, and we send PSPRS the information for a final determination. Well, because statutes required you to notify us within 10 days, we would already have that information, and we would be reviewing that internally. Just like with any decision that's made by a local board, it does go through a review here. So it goes through our legal counsel for review to ensure that's within state statutes, and if there's going to be any request of rehearing, it would come through their office in conjunction with our administrator and deputy administrator. Because we may have that information prior to a local board taking action, depending on the situation, we currently don't have specific protocols that says we will automatically suspend it. I think it's going to be on a case-by-case basis. If it seems pretty clear-cut to us based upon the information that you as an employer have provided to us that there is a violation of return to work rules, meaning that the individual returned back within 60 days or the member returned back to the position from which they retired, we may be given direction by our legal counsel that we have the authority to go ahead and suspend that pension. And we would maybe do so, and then follow up with our local board, to ensure that they've ratified that decision to be in compliance. Or, again, we may just hold off until the local board makes their final determination, because we know that the local board has that information in front of them, and they will be conducting a local board meeting within the near future. So it's not always a clear-cut yes or no when it comes to we will automatically suspend it. It's taken on a case-by-case basis based upon the information provided to us, time frames, etc. Our next question. Is the employer expected to submit the ACR for a contract employee, or is the contract agency expected to submit that ACR? Well, under statutes, that requirement is an employer requirement. So even though you are contracting the services through some third-party agency, you as the employer have that cost responsibility and the responsibility to submit that contribution directly to the system. We don't partner with third-party vendors. We don't work with third-party vendors to collect contributions. We only interact with our participating employer groups. So if you are using a contractor to fill a PSPRS covered position and that contractor is a PSPRS retiree, then you as the employer are responsible for submitting that contribution. Our next question. Many employers feel that the imposition of an ACR may cause the employer to not hire a retiree due to the cost, which may lead to discrimination claims. How does the PSPRS respond to this concern? Well, we don't respond to this concern at all, because what we are concerned with is we are concerned with pension-related issues, and our pension-related issues are within state statutes. And so since state statutes dictate that an ACR is required under specific situations, meaning PSPRS or CORP retiree into a PSPRS or CORP position, we're only concerned with that issue. And if that issue is in place, then the employer is responsible for submitting that ACR. If the employer decides to make employment decisions or take policies associated with now this ACR in place for cost reasons, that's strictly an employer level decision. We are not involved in that whatsoever. So we don't, as a system, take a stance with respect to this particular question. Our next question. If an employee retires from PSPRS and comes back to work for the same employer, but not in a PSPRS position, is he or she still subject to the 60-day waiting period? Yes, they are. As I mentioned before, under public safety, when it comes to the 60-day provision, the language clearly states that the member cannot return back in any capacity within 60 days. And when we say any capacity, we mean any paid capacity, any paid position, any position that the employer has available for that member. We're not just strictly under public safety. We're not just strictly looking at public safety covered positions for that first 60 days. We're looking at any position. So if this PSPRS retiree, police officer has an opportunity to, work some sort of administrative role in some department outside of the police department, we are still concerned with that because it was a violation of that return to work rule because it's any capacity situation. Our next question. Very good questions here. Your last FAQ states that the ACR is required even if retired less than 12 months. But doesn't the statute state that the ACR applies only if retired more than 12 months? Well, you're right. There is some language in the ACR that kind of talks about, this specific section is dealing with CORP when you talk about the 12 months, that there is some language in there that has something to the effect that it applies to members who have been retired after 12 months. Well, I would recommend that you contact your legal counsel from a local board and employer perspective to have them weigh in. What we are looking at and what we're concerned with is what the intent was of that legislation. And truly the intent of that legislation was to cover any situation in which an employer was hiring back a retiree from the plan and putting them into a position that traditionally is covered by the plan and under normal circumstances would have an active contributing member. The whole intent of this particular ACR has to do with this whole the funding status of the plans. And our legislators, realize that if employers are making these type of decisions and putting them into positions that are covered by the plan, that's not gaining any type of contribution inflow into the system, which again affects funding statuses. So this was their way of addressing those situations. So their intent behind this legislation was to cover those situations in which an employer is putting a retiree of the plan into a position that's covered by the plan. Our next question: if a PSPRS person is suspended for a violation, will that person just simply return to that pension again when they separate from employment again? Yes, they would. What happens when there's a situation in which a violation of the return to work rules is in place and a member's pension must be suspended and the action has been taken by local board to do so? Once that member terminates the employment that they're currently in, we would then reestablish their pension or start their pension back again, and they will start receiving that pension going forward. It's important to note, though, that we will not be doing any retroactive payments during the time in which they were employed, nor would we be looking at any type of recalculation of any benefits. It would strictly be that situation in which they terminate employment, we'll just start their pension back up going forward. Our next question: does the ACR apply to those folks currently in a PSPRS position who were not eligible for PSPRS membership in years past, but maybe due to age, etc.? No. Again, the ACR strictly is dealing with PSPRS retirees. If that member is not a retiree from our plan and they are in a position that is traditionally covered by the plan or is now covered by the plan, then the ACR is in place. If the person is not a retiree from our plan whatsoever, the ACR is not an issue at hand. Okay, we'll take another question here. It looks like we have a question from our in-house group. Okay, it sounds like for our online participants, the question was, when we talked about required documentation when it comes to reemployment decisions from the employer perspective and local board perspective, do we as a system have required documentation when it comes to reporting the alternate contribution rate, or the ACR? Well, at this point in time, we don't have specific written documentation requirements from our employers or local boards to notify us of any ACR-related issues, meaning you've hired a PSPRS or CORP retiree into a PSPRS or CORP covered position. All that we are expecting once an employer has identified those situations or identified those individuals, that they then just begin to submit the contribution on their behalf in their normal contribution reporting fashion. So there's no additional written requirement or additional form that they would need to provide PSPRS identifying an individual as ACR. It's kind of at this point we are requiring our employers to self-identify those individuals. That's not to say that in the future, if we start looking at compliance and audit of these particular type of scenarios, that we wouldn't develop those type of forms. But at this point in time, we don't have any required documentation in that perspective. We'll go ahead and take another question, and we'll take this one from our online group. Let's see here. On average, how long would it take for PSPRS to make a determination as to whether or not to suspend a pension if we notify you of a reemployment of a former employer within the 10 days as required by statute? Unfortunately, there's no clear-cut answer to say within X amount of days we as the PSPRS Administrative Office would take the necessary action, whether it's suspending an individual's pension or moving forward and determining that it's not in violation of the return to work rules. And that's just because of timing. It depends on the timing in which the employer notify us and at what point of pension processing we're in, whether there's even times to allow for such action to occur. It depends on the interaction that we're having with a local board with respect to this notification by the employer, and how soon the local board may be making a decision with respect to this reemployment of a retiree. It depends on, the legal counsel's review of the information that was provided by the employer. So unfortunately, I'm unable to tell you, once you as an employer notify us, within X amount of days, we will have a final decision on what's going to transpire, whether it's a suspension of pension or whether there's no violation in place. So I apologize, but there is no clear-cut answer to that one. Our next question is, are there forms to use for notifying PSPRS of that reemployment? Again, kind of in the same respect with the ACR issue, there is no official form that PSPRS has that an employer could use or a local board could use when making the notification of reemployment. As I mentioned before, when it came to public safety, we do put some guidance out there from a local board perspective on what type of documentation they may want to put into place, those affidavits from employer or employee, the copies of job descriptions, and then obviously absolutely minutes, because you are as a local board required to submit minutes on any action taken. But there's no official PSPRS form that the local board would complete, nor the employer would complete when they're notifying us of those reemployment actions. But again, as participating employers in our plan, you probably know that we always update documents, forms, procedures based upon guidance from our legal counsel, based upon changes in legislation. That's not to say that in the future we wouldn't have those type of documents in place, but currently right now we do not. Looks like we have a question from our in-house group. Okay. It sounds like this question is dealing with vacation and leave, if I'm understanding. The question is, are we as a system, do we have any processes in place with respect to employers paying out leave, sick time, etc.? Are we concerned with that, or do we look at those things? Well, unfortunately we don't, or maybe fortunately we don't, because each employer has their own policies in place, how they deal with sick leave payouts, any type of vacation leave payouts. We're not concerned with that. It's important to note, though, if you are an employer, if you do have those policies or procedures in place, when the IRS was to ever review actions taken by employers or review our plan, and you as employers have those policies in place, that would substantiate potential decisions of showing that a bona fide separation of service has occurred. So if as part of the retirement process you pay out sick leave, and you have done so for individuals when they retire, then that could clearly show to the IRS that you have done a bona fide separation of service and employment relationship with this individual and that they have officially retired. Conversely, if you have those policies in place and are not adhering to them and doing these reemployment of your own retirees, that could be a question by the IRS or a red flag for them on why those policies are not being adhered to, and has there truly been a bona fide separation of service. But from the perspective of the system, we don't monitor that, we don't look into that. It's just something that maybe you as an employer and local board should be aware of. Let's see, looks like we have maybe one more question here. With a reemployment of a former employee, if PSPRS makes a determination within the 10 days to suspend or to not suspend the pension, why do we still need to send it to the local board for their decision? Could we send it to the local board as an FYI? Well, no, not just as an FYI. It still needs to be sent to the local board, because going back to statutes for both PSPRS and CORP, that local board for your employer group and for that eligible group is vested with the responsibility of determining all eligibility of membership, benefits, service credits, etc., etc., etc. So they have the vested responsibility to determine whether or not someone is eligible to continue to receive a pension, meaning they need to review those reemployment decisions and make a decision on whether a pension has to be suspended or if the member is within the provisions of statute and can continue to receive their pension. So while you as employer, especially on the public safety side, are required to notify our office and provide us with information, and we may take steps to suspend the pension based upon that information, there's still that requirement to notify the local board, because the local board must ratify those type of decisions and, either confer with what we already went through in terms of suspending the pension, or they may think contrary, and then that's when rehearing processes come into place, both from the administrative office perspective of member, et cetera, et cetera. So it's not strictly just an FYI to the local board. It truly is a notification to the board so that they can take proper action on any reemployment of retirees. So it looks like that might have been our last question. Again, I thank you all for participating in today's webinar. We hope to have this webinar archived and presented on our website, along with all future webinars. If you do have any questions that weren't addressed in today's presentation that you come up with later, please don't hesitate to send me an email or send Dawn an email or give us a call. We're more than happy to help with you on those questions. And again, if you as a local board or employer have specific training requests, also please notify us. But we hope that you found today's presentation useful, and we thank you for your participation.